Hello, everyone. Welcome. Thank you for joining our webinar, Real Estate Financing in India, Current Trends and Recent Developments, presented in partnership between the Legal 500 and Trilegal. This is our third episode in collaboration with Trilegal. We held the first episode in June and the second in August, and I highly encourage you to watch these two on our YouTube channel. My name is Alan Cohen. I'm a research editor at the Legal 500. And well, before I hand over the webinar to our panelists, I'll give a brief introduction of today's topic. As the title suggests, we will discuss how, as India continues to grow, the real estate industry in the country is undergoing significant changes influenced by government policies and the availability of credit. The pandemic necessitated certain measures to bring transparency and access to credit in the sector. And today, the discussion points will include questions such as how effective have those measures been, how do lenders and investors perceive the Indian real estate market now, and cover other aspects of the question, such as the real estate debt restructuring during the pandemic, the rise in demand for warehousing and office spaces, how investors are looking at the increased cost of credit because of the inflation, the market of the data centers, and a few other points. But first, let me introduce Pranav Sharma, who will lead the discussion. Pranav, I don't know if you want to say a quick hello so everybody sees who you are on the screen.
Hi everyone.
Pranav is a partner in the banking and finance practice at Trilegal. He has 20 years of experience and specializes in banking and finance and debt capital markets. He acts for leading banks, financial institutions, and other credit providers on all forms of onshore and offshore financing, and also regularly represents sponsors and borrowers in projects in the road and highway, power, telecom, hotel, and steel sectors. He's also advised a wide range of government agencies, state-owned enterprises, and leading companies in India and abroad, particularly in Eastern Europe, Russia, Turkey, and Africa. He is qualified in both Indian and English law, and prior to joining Trilegal, he worked with a leading Indian law firm and was a managing associate at a well-known banking group in London. Also joining us is Siddharth Ranade, who is also a partner in Trilegal's dispute resolution practice. His primary areas of focus are corporate and commercial litigation, arbitration, and insolvency resolution related disputes. He has represented various Indian and multinational clients in complex corporate and commercial disputes before various courts and arbitral tribunals in India. He's also advised on pre-litigation and strategic issues in various commercial disputes, as well as on enforcement and arbitral awards and decrees. Okay, I'll hand over to you in a moment, Pranav, but before that, I want to let our audience know that this session is interactive. So if you have any questions at any point during the webinar, please submit them using the Q&A function, which you will find at the bottom of your screen, and we'll answer them at the end of the presentation. Okay, then, Pranav, I'm handing this over to you now. Please, feel free to introduce the topic further and really get us on the way.
Great. Thanks very much for the introductions, Alan, and a very warm good evening to anybody joining us from India, and a very good time of the day to all those joining us from other time zones. I think when we look at the topic itself, real estate financing, there is frankly a whole lot that we could cover, within that area. But as we were preparing for this webinar, I started chatting with Siddharth, who's my fellow partner and specializes a lot on insolvency, restructurings, and debt recovery. We had a very honestly interesting dialogue between the two of us in terms of what he's seeing on the IBC, the ongoing resolution or restructuring side of things. And then as far as I'm concerned, when we are structuring and putting together new transactions for our clients, or when we've been advising borrowers in terms of, financing structures, there are very clear correlations, very clear themes in terms of how financing in India actually, I mean, the largest story was when IBC first came out, right? It was a huge shot in the arm for the Indian debt market. Because again, very, very briefly put, pre-IBC, there was only really relationship lending or high risk lending, because given the litigation challenges in India, lenders did not really have an efficacious remedy in case there was a default on the debt, right? There were obviously previous attempts. There have been DRTs and other special remedies under SARFAESI, but for different reasons, they were not giving the confidence to the lending community. Then 2016, IBC comes along. We saw a real positive interest from the lending community. And again, in the first couple of years, there was original legislation which was being implemented, challenged all the way from a lower tribunal level to High Court to Supreme Court level, right? And then the law started changing, because as the court started interpreting the law, the parliament started stepping in, there were lobbying efforts, certain provisions started changing, new elements started coming in. And therefore, we've been in this, a virtuous cycle of either judicial change or legislative change. And then you've got a lending market responding both at the new money stage as well as at, say, a distressed debt or a resolution stage to all of these changes in a live dynamic fashion, right? So, I mean, in long story short, when we were having this conversation, we discovered very common themes. We were discovering that, okay, some of the key concepts that we have taken or held to be, say, well developed after the IBC came in. So whether it was on, security structures, priority of debt, or whether it was on, is this literally a press the button recovery tool for a financial creditor, that as long as I have a financial default above a specified threshold, I literally can then just keep the borrower, as a lender, I have a very clear, immediate right of enforcement, right? So a lot of these themes have been challenged, or maybe they need to be reassessed given both judicial as well as legislative developments that have gone on. And so we thought that the best thing to do is to keep this as an interactive dialogue where, Siddharth will, of course, come in from his perspective, both as a litigator and as a resolution focused professional. And then from a new money side, I will obviously comment saying that when we're trying to structure these deals, how are these same themes coming through in terms of what we are hearing from the lenders, what are we seeing as a response to those issues that these lenders and borrowers are now facing. So without further ado, let's just dive right in. And again, we thought we'll keep it more conversational, certainly between Siddharth and myself. So you will see a bit of back and forth. We don't want to be news readers and bore you with a prepared text. So I hope you find this helpful. And again, the limitation of this format is we cannot give you very exhaustive, clause by clause, full stop, comma, dissection of all of these legal issues. But we hope these will be of interest. And, should you have any questions after we have a Q&A format, we are happy to take those. And in any case, you have our coordinates. We'll be happy to, for more detailed issues, discuss them directly with you. So Siddharth, I think one of the things when IBC came out, right, and which the lenders were very, very excited about was because I know we made so many presentations to everybody saying that, hey, I know you've been facing challenges with DRT and SARFAESI in general, civil court enforcement of debt claims. Other than, say, share pledge enforcement, everything was really a challenge, right? And we consistently would tell all our lending clients that absent a dematerialized share pledge, a lot of the security is time intensive and painful to enforce, right? And then IBC came and we started telling everybody that, hey, this is a great piece of legislation. all you need is financial default. If say you are a lender, your loan, there has been a payment default above a specified threshold, that's really all you need to put in your claim, and you have a actual deterrent or actual remedy vis-a-vis the borrower by saying that I will put you into insolvency, and the insolvency will obviously take away control, management control, and asset control from the borrower, right? But I know the Vidarbha judgment of the Supreme Court has got a lot of attention. So do you want to just walk us through what has it really changed in terms of how the statute was originally written or interpreted, or again, understood by the community, and what do we really see? How is that changing the position, and what is the practical consequence we're seeing on live resolution matters that are going on?
Yeah, thanks, Pranav, for that context. I think, like you rightly said, when the IBC came in, generally the market was very sanguine about one thing, which was missing in the other sort of statutes and other remedies available at the time was speed, right? I mean, speed and a certain element of objectivity in terms of process. That if there is a debt, if there's a default, then at least the triggering of the process is something that the lenders can be rest assured of. And that's how the whole code is structured. I mean the way the provisions flow, it really is a creditor in control model, whereby as soon as there is a default, there is a distress situation in the company, the lenders will be able to take control, and it's a one-stop shop kind of a solution, where instead of going to the DRT or going to the SARFAESI, you can just invoke your rights under the IBC and start a process which will result ultimately in a resolution of your debt and also of the company. So that's how all of this was really contemplated, and which is really why the initiation of the process is meant really to be a very mechanical sort of an approach, whereby once you show there's a default, it must be admitted in insolvency. And like we, all of us who are insolvency practitioners here will have seen, by and large, the approach has been followed since 2016 up until 2022. The recent Vidarbha judgment, and I'll come shortly as to what that Vidarbha judgment really does. But prior to Vidarbha, I think it was absolutely clear that there is no discretion that really is there within the NCLT to decide as to whether it can reject a petition or it can defer admission of a petition as long as there is a default. And showing default really was not so tough in terms of a lending default, because there is information utility, there is financial statements, obviously. So there would never really be a dispute on the existence of default. So it was a fairly straightforward process, and that's how everyone understood the law to be, that there is no discretion. But the decision in Vidarbha, what it does really is that it opens up the possibility of now borrowers saying that, hey, look, there is a default. I understand I'm in financial distress, but that doesn't necessarily mean that you will trigger an insolvency and put me in IBC. That opening of that slight window in Vidarbha is something which we need to, I think, as practitioners and as stakeholders in the process, need to look at very carefully, because what it does is that it to some extent obviously dips into the confidence that people had into this in the statute in terms of the process. So just to give context on the judgment itself, basically what the court says there is that merely because there is a debt and there's a default, that doesn't mean the NCLT is required to initiate CIRP, and it is required to look at other extraneous factors. And other extraneous factors in the given case really was that there was, according to the borrower, an award in his favor, which would result in recovery of a significant sum of money, which would be sufficient to pay off the debt ultimately. So what is really important now is post the Vidarbha judgment as to how the courts would interpret it, because the problem with discretion, like we all know, is that once that window of discretion is opened, the way it can be used and misused, and the way there can be variations to that rule, is something that no one can really control, which was the whole point really in having a statute which laid down certain bright line tests for putting the company in insolvency, because that was not there pre-IBC. So I think the what is going to be very important now post Vidarbha is how courts interpret the judgment and apply it in their cases. For example, what is it that we mean when we say that a person has or that a corporate debtor has a certain award in his favor? Where do you extend this example to? I mean, what if there is no award, but there is just some ability to pay, but that ability to pay is not present, and that there is some likelihood of a payment that may happen in the future? So some contours need to be set. If the Vidarbha judgment is to stay or as good law, then I think what is really necessary is that some contours need to be set to identify some objective tests as to how to apply that Vidarbha, apply that kind of a line of thinking. So, for example, what we are seeing now in some instances, and this is also something that's being argued in live matters that we see in the NCLTs, because even the judges are grappling with how to apply the judgment, because the judgment does not lay down any test per se. It is for the subsequent courts to really lay down a test to apply that rule. So I think what is slowly sort of developing is that just to make sure that there is some discipline in this approach, is that the courts are, I feel, veering towards an approach that when you say there is a prospect of this being resolved without having to put it in IBC, then there has to be some time-bound nature to that prospect, in the sense that it is only in a situation where there is a foreseeable prospect of payment in a certain definite time frame, which the borrower is willing to put his word to, by way of a settlement terms, etc., or by way of some undertaking in court. Only in that case, perhaps the admission can be deferred, but otherwise the admission will be or must follow. I mean, that discretion has to be exercised in favor of admitting the petition rather than deferring it or rejecting it. So I think that's broadly where matters may move going forward. I mean, that's the sense I have personally.
No, because as you were saying, Siddharth, it's a very interesting point that all the judgment says is that it is not black and white and there is discretion which the court can exercise, right? But it doesn't go on to say what are the grounds on which or what are the limits to which that discretion can be exercised. And that again will become a matter of litigation, because adventurous borrowers will come up with ingenious arguments. I mean, in a simple, say, a residential real estate project, right? Just a very simple type of situation. Any developer would say that, hey, I think this is, say, a good season. I anticipate sales are picking up. I've got 35 inquiries. And if I convert this into sales, then I'm going to get, over the next 60 days, I'm going to get X crores of receipts. And that is enough to meet your installment, which I've missed, right? So I guess on the facts of Vidarbha, it was on total debt. But I mean, it's a slippery slope. You can now start interpreting it to mean that if the payment default was of, say, an installment of debt, a repayment installment, not the whole debt, but, the company is pointing to a revenue potential source and saying that in the next 50 days, 60 days, whatever it is, I see a clear cash income, which I can then use to repay you, right? It effectively becomes like an implied court-blessed cure. This is simply, it runs the risk of taking away the certainty of obviously no lender is just going to go file IBC. There has to be a certain dialogue between the two parties. But if you don't even have certainty that, okay, if I'm calling off moving into enforcement, whether or not I'm going to be able to 100% get my claim admitted, it may make some lenders wary of calling defaults.
Yeah, that's right, Pranav. I mean, the post the judgment, that's the feedback that we've been getting generally when we are speaking on live matters, plus also on other sort of engagements with clients. But I think what is in that sense reassuring is that when we look at how this judgment is being thought about in the market generally and by judges, they do understand that this rule can't be extended to a point where the whole code becomes impractical. And there have to be certain very, very clear rules or clear sort of boundaries within which this sort of discretion has to be exercised. So I think, like I said, it is moving toward in that direction. It may take some time. Perhaps I also understand there's a lot of sort of discussion going on in terms of making direct amendments to the law to clarify that the power was never meant to be discretionary and that it was mandatory. I think if that happens, obviously that helps the cause and serves saves a lot of time and effort from the standpoint of someone tomorrow laying down new law and interpreting this. But I think I do see that in the next few months or a year or so, there will be a reading down of the kind of law that has been laid down in Vidarbha, in terms of in what situations should this be applied. And certainly I see that it will become more of an exception than a norm. Obviously, there are attempts from borrower sides all the time to try and delay, and they will argue that that it has to be a norm that has to be considered in every situation. But my sense is that it will become more of an exception than a general rule.
Sure. No, let's hope it comes back, because clearly the lending community wants it to be where it was, and they would rather have either a legislative amendment or a very narrow interpretation to this, because otherwise it takes away the whole threat of an IBC proceeding. Absolutely. Coming to, again, one of the other kind of key concepts of IBC, which we banking lawyers had taken away, right, was that, I mean, in a real estate context, frankly, you would either be lending at a like a big company, like a big holdco, which has multiple projects and therefore multiple lenders in it. And then the initial reaction, because of the whole IBC regime, there was a preference, or at least an attempt, to try to do SPV-backed lending, which is try to see if you could warehouse, one project in one subsidiary or an SPV, and then, be the sole lender to that SPV, so that in terms of your IBC rights and destiny, you had pretty much control over it, right? But I think the market over time digested IBC, and lending to holdcos, or like lending to a company where you were, say, a minority creditor, right, again has started becoming prevalent or common, and we're seeing it often enough in the market. And one of the things that I remember we have given a lot of advice and comfort to clients has always been that, hey, listen, as long as you are backing a specific identified project, right, your underwrite of that project in terms of your quality of collateral, the value of that collateral is good, right, and you're an exclusive mortgage holder or charge holder on that project and its receivables, right, that even though you may be only a fraction of the total financial debt of the company, and even if there was a risk that, say, one of the other projects or one of the other loans went bad, which led to a insolvency situation of the borrower, you as a lender would always have that ace in the back of your hand, that you could, if you didn't like the resolution plan, you would always be able to vote against it, be a dissenting creditor, and your liquidation value is enshrined into the IBC, and that was your protection, that as long as you had high quality collateral and an exclusive mortgage, your liquidation value should be your protection, that even if you didn't like the resolution, you could be a dissenting creditor, right? Now, is that something which still is a fair statement according to you, or is that getting diluted because of recent judicial trends?
Yeah, so I think, see, if you look at barely the statute, I mean, it's quite clear. The idea under the IBC is that, and especially for lenders who may vote against a resolution plan, and typically lenders who vote against a resolution plan will be those who don't have a large size of debt, but they feel that they are shortchanged either because the general payouts are not commensurate to the value of their debt or to the value of their security. So the code itself is quite clear that if you are dissenting on a plan, you must be paid liquidation value. So that's one. Obviously, there was not enough clarity on what is it that we mean by liquidation value in the context of a particular creditor. And we always expected litigation on that front in terms of just quantification of the liquidation value. But I think the one important sort of development here is there have been a couple of judgments which have, sort of undermined the entitlement to receive liquidation value in the context of a dissenting financial creditor. So again, here we are talking of judgments which turned on their own specific facts. They don't obviously, and they cannot go beyond what the section says. But I think, for example, the Amit Metallics judgment in the Supreme Court, it's a Supreme Court judgment where I think a dissenting creditor had challenged the resolution plan, and which went right up to the Supreme Court. And his case was that I must at least be paid my liquidation value. And in fact, in that case, the creditor was exactly the profile was exactly what we are discussing, that the creditor did not have sufficient debt to be able to vote in favor of the to basically vote out the plan, and therefore but he had valuable security. So therefore I'm sure the creditor in that case voted against the plan on the assumption, on the premise that he would get liquidation value and that would protect that creditor's interest. But I think what the Supreme Court says over there is that that is not a hard entitlement, as long as you are treated at par with the other assenting financial creditors. As long as your payout is by and large, similar to what the other assenting creditors are getting, you cannot necessarily insist on getting paid liquidation value. I mean, it's a sort of an equitable approach that perhaps the Supreme Court adopted in that matter, because perhaps the facts of that case warranted it. I mean, I don't think they did, but be that as it may. I mean, so therefore, I think this is something where a bit of debate needs to happen at, in terms of making things clear within judgments as well as in the code, that that this is absolutely unexceptionable. That once you are a lender who dissents on a plan, the value of a security must be protected. Because, and this is all the more important because the way the code is structured, the voting share is based purely on the value of the debt, and the security does not really have. There is no weighted approach there to say that the value of the security also will be taken into account in deciding what voting share you have. So therefore, if a small lender who does not have the choice in terms of how the COC is to be run, then his rights must be protected all the more. So I think that somewhere, in terms of case law, some clarity is required, especially in light of the kind of judgments that I was talking about. But otherwise, I think the code itself is clear. It's just that the interpretation needs to come out absolutely clearly that getting paid liquidation value is something that is totally unexceptional and will always happen.
I think just staying on this sort of a broad area, one of the, at least as a new money lawyer, hotly debated with very kind of different views out in the market subject is around, does IBC really recognize a first ranking security interest vis-a-vis a second ranking security interest, right? So in terms of like, if you had to layer up a debt structure for a potential project or for a borrower, there may be, say, an appetite where you're trying to place the debt with different types of lenders with different risk appetites, right? So, I mean, pre-IBC, obviously these deals would happen, and I mean, anecdotally as well, these deals are happening, but they become much more contested now and much more lawyered up. So how do we see that playing out on the IBC side? Like, are courts in IBC recognizing the fact that, say, a first ranking security holder should get a preferential payout vis-a-vis a second ranking holder? Or again, is it like the case you were mentioning where, say, there's a watering down or a equalization treatment that is happening because essentially you're bunched in as a category of secured financial creditor rather than a clear tiering of, say, first and second debt?
Yeah, I think even there, Pranav, the problem is very similar to the one in the context of an exclusive charge. I mean, what we were discussing prior, the Amit Metallics judgment. So the problem is similar in the sense that the IBC does again recognize or take note of the concept of priority and ranking. For example, when they talk about resolution plans, there is a provision which says that the committee of creditors will take into account priority and ranking of security interest. in terms of deciding what the distribution should be. But the problem really comes exactly like the exclusive charge situation in a case where your debt share is small, so as in the manner that you don't have sufficient voting share on the COC, but you have a charge ranking which is higher than some other creditors. So that is really where problems come, because if your debt share is sufficient to sort of drive the COC decision making, then you will ensure that you're paid out according to your ranking, according to the ranking of your charge. But if that is not the case, that's where the real risk is, because the problem is again in terms of how liquidation value is perceived. So, I mean, the whole idea of liquidation value was that it should be the value of your security interest, really. And when you say value of security interest, intrinsically, the priority of the charge has to be taken into account. I mean, that was the position pre-IBC also, say under the Companies Act, where priority of charge was required to be taken into account. It's 101 property law, right? I mean, section 48 to follow that. You must take into account a prior interest, the fact that a prior interest will take precedence over a subsequent interest. So that legal rule has to translate into valuation as well. So that was the thought process, right? Even when the IBC came in, that is in fact the thought process in terms of resolution plans where lenders do have the ability to decide distribution. But oddly enough, when it comes to liquidation value, the view, and this is something which is in that sense pending before the Supreme Court, but the view that has been taken by the appellate tribunal seems to be that the distinction between first and second charge, for example, is not really contemplated when it comes to liquidation value. When it comes to the liquidation waterfall under the IBC, that you will not necessarily take that into account. So that is where there's a bit of an issue, and in terms of lending, one has to be careful where there's a risk that if you are in a position where you don't have sufficient control in terms of voting share, but you have a superior charge, that superior charge may not necessarily play out as a superior charge in a liquidation scenario. In a resolution scenario, again, it might be slightly different, but there is still a problem if your voting share is low, because there again there's a risk that you may get shortchanged by those who may have an inferior charge but have a larger debt.
And just as a follow-up to that, right, because what we've seen on deals are attempts that, because people are cognizant of this issue, that this may not exactly play out the way we would like it to. We've seen, say, lenders trying to sign up to intercreditors, right? Yeah. So you may have, say, intercreditor between a senior lender and a junior lender, where you're trying to respect it and say that regardless of, say, how the resolution plan will pay you out, but say, lender A and lender B, what we're agreeing is this formula or this kind of a treatment of any recoveries, right? Yeah. So, I mean, again, I know it's an interesting area which is still developing. But any thoughts? Do you think, how is this going to play out? Obviously, I suspect a resolution professional is just going to ignore it. So it really can't operate or be binding on the RP. But what are your thoughts? Do you think if, say, you had to enforce one of these before an Indian court, do you see challenges?
Presently, there is really no clarity on how a RP will deal with these. Although the general sense is that they will not bind the RP. The other problem also from a pure IBC-centric enforcement is that if Section 53, like I said, has been interpreted to mean no priority will be respected, then how can a contractual priority be read into 53? I mean, I think it can still be read into, but the risk is that a court may say that if 53 doesn't contemplate it, then perhaps contractually it cannot be done. But I think the one thought, one aspect that should perhaps be considered is, although the IBC or the liquidator RP may not be bound by an agreement of this type, is there merit in saying that it should at least be enforceable as between lenders inter se? In the sense that, say, for example, in case of shareholders agreements, there were judgments that while it may not bind the company, inter se shareholders, those arrangements are still enforceable. So that's one aspect which can perhaps be developed going forward. And I think an overall sort of framework is required whereby these arrangements will be respected even in the IBC, because these are commercial realities of how transactions happen. And perhaps it's only that when the code was written, obviously not all of these things were taken into account while writing, and it's really for the courts to interpret the law in a way that accommodates all these commercial realities. Perhaps that has yet not happened to the fullest extent, but I think the tribunal also needs to be sort of sensitized to these things in terms of their practical relevance, so that it can find expression in the judgments they write. So that's
It's very interesting you say that, because it actually lines up with what we are seeing live, right? So these arrangements and these structures are only working where there is counterparty comfort. So it's not that people are agnostic to say who the junior lender is and they'll just sign up to the deal. It's very, very specific. It's that as senior, I will only accept this kind of a contract and this arrangement if I know who the junior lender is and there is a high degree of counterparty comfort. And it is purely on an institutional basis that effectively people are taking kind of extra court confidence in each other. It's that the contract will perform, and not because they're taking enforcement assurance on it. Interesting. And I know there's a lot of good news we have been sharing with people who've dialed in or logged in. But I think just to finish off on the bunch of good news pre-Christmas, there was also that rainbow judgment, right? Where suddenly we've got the specter of government dues rising up and competing against lender claims, right? So if at all the last thing a lender wanted to hear is that my recovery rate could potentially go lower, now we also have this issue. So is it really that all government dues potentially can now become competing creditors, or is there more assurance that we can give people that this can be narrowed down to a very specific type of a government or a tax due?
Yeah, I think, that rainbow judgment is certainly, in that sense, a bummer from the standpoint of recoveries for lenders, because again, the general practice was that statutory dues would get wiped out in the resolution plan, and there was never really a discussion on statutory dues getting priority per se, which is on the basis of any charge, etc., which is exactly what the rainbow judgment does. So that is a concern. The only sort of only point over there to sort of note in the rainbow judgment is that it arose in the context of a statute which provided for a first charge in respect of the MVAT dues, the Gujarat VAT dues. So therefore, I think that's one aspect which perhaps is a saving grace over there in terms of how it may play out, in the sense that for statutes or for tax dues where there's no first charge created, perhaps the position will be slightly better from a lender standpoint, where we may still be able to say that lenders' dues will get priority under a resolution plan, and a tax due which arose subsequently to the lenders' dues will not be paid at par or pari passu to the lenders' dues. So therefore, I think that's the only thing which perhaps is a takeaway there. That while yes, it is slightly problematic in terms of how now we will have to look at statutory dues. But I mean, if you look at the facts, it arose only in the context of a statutory first charge. Now, for example, even in the pre-IBC or even in the SARFAESI regime, I think the position is that if there's a statutory first charge that's created, then that will have to be paid out, in the sense that it doesn't then matter whether the mortgage is pre or post that tax due become due. I mean, that amount becomes due.
Got it. Okay. So I know we've been speaking about this, but one of the, again, main themes, or one of the common issues that we spend a lot of time as banking lawyers debating is, the scope or the universe of financial debt. But there were obviously creative attempts in terms of trying to see what kind of recourse and other things we could shoehorn into that. I think a lot of that has fallen away now. But one of the things that, 101 of, say, banking law, we always assume that where you had third-party security, right? A third-party security provider, because customarily all of these security documents contained a covenant to pay, right? Because from a enforceability or validity of the mortgage security or the third-party security, you needed that covenant to pay, right? And when IBC first came out, most banking lawyers were pretty confident that a covenant to pay in a security document would tantamount to effectively financial debt, because it was a commitment on the part of the mortgagor or security provider to repay the financial debt, right? But then, of course, you had the JP judgment where I think the takeaway after that was that no, you can't possibly, or you couldn't 100% rely on a covenant to pay amounting to financial debt. And then market practice flipped, where everywhere, people were pushing for a guarantee. So instead of just taking a standalone third-party security interest, it became the norm, at least for any prudent lender, and all lenders council were advising that back up the security with an express guarantee, because guarantee was one of the enumerated items under the definition of financial debt, right? Yeah. Now, I believe there have, again, some developments been going on where perhaps we may be revisiting, that analysis. So is it still fair to say that a standalone covenant to pay, which is not backed up either by a full-blown indemnity or by a guarantee, right? If you were just, say, a third-party security provider, could a lender get comfortable that we may actually still have a financial debt claim against that security provider?
Yeah, so I think if one is actually negotiating a transaction today, then perhaps there isn't sufficient comfort to be able to say that a covenant to pay will necessarily be respected. But if you look at a few developments post the JP judgment, then they have actually quite clearly interpreted a covenant to pay to be sufficient to sort of constitute a financial debt, in the sense that the interpretation is that it has the effect of a guarantee. And so therefore, even though there's no separate guarantee which is referred to in the definition, that covenant to pay off, or if there is a shortfall undertaking within the security document, then that should by and of itself be sufficient to constitute a guarantee. And in fact, what is interesting is exactly around the time the JP judgment was pronounced, and I think this we are talking about March 2020 perhaps, or slightly before that, there was an IBBI paper which was published around the same time. And IBBI had, in fact, in that paper taken a position that third-party security should be treated as financial creditors. And that was also what the market was thinking at the time. And which is why the JP judgment came as a bit of surprise, because, it also, in that sense, takes a view which is very different from what IBBI thought about it. Obviously, I mean, nothing prevents the Supreme Court from taking a different view. But just in terms of what the body established under the code was really thinking about its own provision, that it was always perceived as a category of financial creditors, really. So that obviously gets diluted post JP. A covenant to pay more or less is people are perhaps getting comfortable, at least from the standpoint of cases where there already is a covenant to pay in documents, and that is the companies in IBC, where you will be treated as a financial creditor basis the covenant. So that it is slowly veering towards that you don't necessarily need to have an express guarantee, and a covenant to pay will be sufficient. But yet, I think the position is not absolutely crystal clear, as would give a person or a client, getting into a new transaction, that kind of comfort that you can work on the basis of a covenant to pay alone. But we are moving towards that. The other thing I think there is also that, one is your ability to, as a financial creditor, you have two rights. One is your ability to participate, and second is the payouts. At least on the second bit, the payouts, that is, even if a third party security holder is not treated as a financial creditor, the other concern also that was expressed post the JP judgment was what happens to my security interest. Because I mean, instinctively, intuitively, also a resolution plan cannot just do away or extinguish a security interest without providing for a payout, right? It's ultimately property rights we're talking about. So I think on that also slowly, perhaps there are a couple of decisions which hint at the position being that even if you're not a financial creditor basis a security document, the security interest will in that sense be protected in so much as you will be entitled to a payout, and that you can't simply get wiped out without being paid under a resolution plan. So I think that's also another important aspect that that lenders would be concerned. That one is my participation in the CIRP, in the sense that if I'm not a FC, I will not be able to sit on the COC. But at least will my security interest be respected in the resolution process in terms of assigning a payout. So I think that also is will hopefully be clarified sooner than later. That the secured creditor must be paid the value of his security, even if he may not be entitled to sit on the COC.
So I think on some hopefully positive news and a welcome development for a change, there was this recent change in the IBC framework where the earlier construct was that you could only effectively in a resolution plan bid for the entire assets of the corporate debtor, right? Like it was a lock, stock, barrel resolution, right? So do you want to talk about the recent changes where actually it is possible now to do a asset-wise or project-wise resolution as well? And I mean, any comments on that in terms of how do you see that playing out, especially in the context of what we were discussing earlier of, a lender who may not have security on that asset, or like how would the proceeds be distributed?
Yeah, I think it's definitely a welcome development that it introduces a lot of flexibility in the process, because a lot of times multiple instances that we saw in the last 3 or 4 years where there were certain very, very valuable assets that the company had. And then there were certain assets which were in that sense valuable, but there were certain serious challenges in terms of getting a buyer for those assets, say pending litigation, regulatory issues and things like that. And that is where I think as RP Council, we would think that perhaps a greater level of flexibility would help. For example, if you look at the liquidation process, the liquidator has the widest array of options available in terms of selling assets. He can do an itemized sale, a slump sale, a going concern sale, and all of that. But in CIRP, that was up until now not really there. It was through case law sort of brought in some instances, like you mentioned, project-wise insolvency. That was brought in fact, by way of a case law, and when there really was no provision in the code. But now there is a specific sort of mechanism that's introduced whereby you can actually call for resolution plans for separate assets rather than necessarily calling for a plan for the company as a whole. So, like I said, definitely a welcome change. It's a very new provision. So, how this will actually get interpreted is yet to be seen. Obviously, even prior to this being introduced, there were instances when this sort of optionality was provided. Like we had DHFL, where the RAs did have the option of bidding for, say, only the retail assets of DHFL. So that optionality was being sort of offered even prior to this amendment, but this only sort of blesses what was perhaps slowly developing in the market. So it'll be interesting to see how it pans out. A couple of very important issues that we as part of this process will have to really deal with. One is how do you attribute liability as between two resolution plans in that case, and how do you attribute, say, something like CIRP costs, the costs you incurred during the process. On that, there's really no guidance. Perhaps logically, it may go, in proportion to the value of the assets. That's just a logical way of looking at it, but there really is no guidance on that in terms of how that will play out. So that's one area where there will be perhaps some developments, discourses, debates in terms of how it should play out going forward. Like I said, it's a very new provision, so the way it will play out in the market in courts is not really clear. Another very important thing that will that will get debated at some point is whether you can do a part liquidation and a part sale, in the sense that in a given situation there would be say one part of the asset pool that which will actually have buyers, which will have bidders in the resolution process, but the other part of the asset pool may not. In that situation, can you take a view that let's do a resolution for these assets where we are getting a buyer and the balance can be put in liquidation? Because the way it's currently framed, the thinking seems to be that the entire company gets resolved. It's only the mechanism that has been changed, in the sense that you can do it asset-wise rather than the whole company-wise. But the idea is full resolution. That seems to be the thinking. We'll have to really see how that gets interpreted as we go forward.
Okay. No, that was very helpful, Siddharth. Thanks for that. I think one other legal development which we keep getting some questions on, and I thought it'll be worth to cover off, was the Supreme Court judgment on share pledges. So again, there is a constituency of banking lawyers in India who will tell you that, hey, there's really nothing new in that Supreme Court judgment, because there's a section of banking lawyers who would say that that was the law as we have understood it and known it. And then there's another section who would argue that no, this is a change in law, or this is a new development in law, right? But in short, really, the core issue is around appropriation. Does the lender have a right to appropriate, right? And effectively, what that judgment is saying is that no, a lender cannot appropriate, right? Yeah. And the right that is available under Indian law to a pledge holder is to sell the pledge shares. So you can't just, take over the shares or take title to the shares as a lender, ascribe value, set it off against the secured debt, and then just basically say that, hey, this is done and dusted. I've become the title holder to the underlying shares which were pledged. And effectively, there has been a transfer of title. I am legal holder. To that extent, there is a discharge of debt, and we can move forward. Because, I mean, obviously, this principle is by itself an important one. But if you ally it to the context where a pledger potentially was going into insolvency, one of the techniques that sometimes was being debated is that, can I potentially beat the impediment of a impending or upcoming insolvency just by doing, say, an enforcement, taking in a dematerialized share, taking it into my account as either lender or trustee, and effectively beating the insolvency of the pledgor, right? Now, I mean, it falls to logic that if the Supreme Court is saying that your right is only to sell, and even if the shares are moved into your depository account that does not constitute title transfer, it equally follows that the title will remain with the pledgor. And should a pledgor therefore, go into insolvency, then obviously they remain assets of the pledgor and therefore, become part of the insolvency estate. So I think it's worth just discussing that. But interestingly, and this is a debate which is still not settled, is the question that, okay, agreed that a pledgor cannot, effectively sell to itself, or it cannot, sell or whatever, appropriate to itself. The question would remain that obviously in a lending community, I mean, you could have an affiliate, you could have, a related party, in a financial institutional conglomerate or a group, there could be other legal entities, right? So is this restriction under the Supreme Court judgment and under the Contract Act, is it to be read narrowly in the sense that it's literally the person who is the pledge holder does not have the ability to appropriate or sell to itself? Or, I mean, could this potentially be construed wider, which is is it disqualifying a sale effectively, which is to my benefit? Because I mean, very honestly, you could find an affiliate or a related party, and you could do a sale backed off a a market valuation, right? So would that sale be kosher, or could that also be suspect to challenge? I think the view has been that really the protection for a pledgor was sale at an undervalue. That the pledgor can't go and the pledge holder cannot sell at an unfair value. They must realize fair value so that there is no unfair treatment to the pledgor. But I think it's one area which the judgment doesn't go into, and potentially it may be a ground where a borrower may be incentivized to litigate or challenge in the future, because it's already we saw an attempt at the High Court level to challenge on voting rights. Luckily, at least in my personal view, the right outcome came out that it was held that no, even though title doesn't transfer, if as per the terms of the pledge, voting rights are available, nothing in the Supreme Court judgment goes against the fact that a lender can exercise voting rights, right? So, but it just shows that a borrower with a well-advised counsel may, look to litigate on this point.
Yeah, I think sorry, please go ahead.
No, go on. Over to you.
No, I was only saying the context in which the PTC judgment sort of brings this into focus. It does open sort of gates for litigation along these lines, along the lines that you're saying. Although I do think that so long as perhaps there are no challenges on undervalued sale, etc., selling to an affiliate will not necessarily sort of fall foul of the rule that the PTC judgment talks about ultimately. But it's also a very intent oriented thing, and it may actually, the answer may differ from case to case over there. But I think the way the PTC judgment goes, there certainly is room for litigation along those lines. Also, the context of the PTC judgment obviously was that it was really a IBC case where the question was whether you should be taken to have appropriated the shares to yourself, and how will that play out in an IBC context. So that context also is perhaps relevant in terms of what the Supreme Court laid down ultimately. And then, like you said, you have the Yes Bank judgment in Dish TV, where they said that notwithstanding what PTC says, it really nowhere significantly changes the law. And if the pledge agreement provides for voting rights to be exercised, then that right will still be available to the pledgee post invocation, even though he may otherwise not have title to the shares. I think that was, to my mind, a welcome development in terms of how the pledgees will sort of react in a situation where they are required to invoke. The one situation that at least to my mind is not fully dealt with yet in the context of this ability to exercise voting rights and how it can play out in IBC, is that suppose a pledge is invoked and the pledge agreement provides for voting rights to be exercised by the pledgee. How does that interplay with the concept of, say, a related party under the IBC? Because even though you don't have title, if you have voting rights over shares and which cross the threshold under the IBC, how will that play out from that lender standpoint? Because if you are a related party, you are out of the COC, for example, as in you can't vote in the COC. So that's one aspect which perhaps, at least to my understanding, there isn't complete clarity on that. There is a proviso, obviously, where in the IBC which says that if a bank or financial institution does it, but if it's not a bank, I mean it's a non-banking.
Could be a debenture trustee. It could be
exactly. So over there, perhaps there is still that bit of a gray area where you may have voting rights, and that could potentially result in issues in terms of your ability to sit on the COC, depending obviously on what the threshold of shares is. I mean, how many shares have you invoked? Perhaps a safer approach would be to invoke only such number of shares as would keep you safe from that related party standpoint.
You know, it's a very interesting point and one we should obviously explore. But I think it's getting a bit late in the evening here in India, so maybe we should pause here and throw it open for questions. Just welcome if people have got any questions. Please feel free to ask them.
It was very thorough, actually, Pranav. Sometimes it takes a few minutes for people to actually send the first one, doesn't it? Do you want to maybe carry on or conclude, and if a question pops up, I'll let you know.
Sure, thanks, Alan. I think we've hopefully dealt with a lot of the recent judicial and legislative changes, in particular from the insolvency law perspective, because very honestly, as a real estate financing in terms of the products, whether it's a construction finance facility or a lease rental discounting facility, those are well settled, well-known products. And it's really what we get are these continuous legal developments where you kind of need to go back, look at your rights and look at your documents afresh and say that, do we really, as Siddharth was just mentioning a bit earlier, in a pledge, do we need to keep the voting rights? Because the standard provision has always been that post an enforcement event or an event of default, a lender would reserve the right to exercise voting rights, right? So, but if there could be fairly extreme consequences of being a related party and losing your seat at the table in an insolvency context, then that's something that, we need to reassess. So the attempt was really to have a dialogue, to socialize some of these issues and our thoughts and views around them. And even if people haven't raised issues here, you now know Siddharth, you now know me, so please feel free to reach out. We are at Trilegal. You can find our details of our website, and we look forward to carrying on this dialogue with anybody who wants to discuss these issues further.
Thank you very much, Pranav. Siddharth, I don't know if you have a few words to add. Otherwise, I'll actually thank you very much. I thought remarkably interesting, and I'm sure it was very useful to the audience. A huge thank you to Trilegal, to you, Pranav, to you, Siddharth, to the audience as well. As you said, Pranav, if anyone has any questions, the Legal 500 encourages people to contact you at Trilegal, and we hope to see you at another webinar shortly. Goodbye, everyone.
Great. Thanks, everyone.
Thanks, everyone.